let's start with part two, and let's start with financial remedies. When we think about financial remedies, I think, Ben, the first problem that coronavirus and COVID-19 causes us as practitioners is whether or not we are able to settle cases right now, and whether or not we should wait and see the impact of all of this. Because of course, there are lots of reasons to wait to see everything settle down. But then again, if waiting in an uncertain time frame, because of course we could be talking about anything, talking about 3 months, 6 months, a year, that probably isn't feasible, is it, to say to parties, well, let's just wait for an unknown period of time and then we'll sort out your finances. What do you think about reaching settlements at the moment in the current climate?
Well, the difficulty we have at the moment is that we're effectively in a fast-moving economic period of time. The markets have dropped significantly over the past couple of weeks, and the price of shares are fluctuating on a frankly daily basis. The difficulty that any person faces when trying to settle a case in a situation such as this is, how does one deal with that risk? How does one deal with the risk of asset values changing rapidly from one day to the next? And when you are dividing up assets following a divorce, you really have a number of very few options. You can, and the courts are told to value assets as at the date of trial. You can value the asset as at the date of trial, whatever that might be, whatever that snapshot is, and offset that with a cash payment. That fixes the value at a point in time. That may or may not be fair to the parties involved. It may benefit one party more than the other. It depends if the price bounces back again or if it continues to drop. You can have a property adjustment order and share the assets in what's called in specie. In other words, that each takes one half, if the half is the appropriate percentage share, one half of the asset in question. So they both take the risk of the asset increasing in value or decreasing in value. Or the third option is you sell the asset in question. You realize the value by testing it on the open market, you sell it, and both parties receive a share of whatever it sells for at that moment in time. But those are really the only few options. It really isn't open to people to simply adjourn their cases unless everyone's in agreement. And even then, you can't adjourn cases indefinitely. There has to be, at some point, there has to be a conclusion. There has to be an end point. There has to be a point at which the court says, right, enough is enough. I'm making an order in respect of this. But this is a situation which arises in any environment where there is uncertainty. And uncertainty and risk is the bread and butter, I think, of the divorce practitioner's toolkit.
Well, two things for you though, Ben. So first of all, myosin and myosin, which comes to our mind always when we think of these kind of situations. Can people, so if people do plow on and reach an agreement with all the uncertainty that's around, we know that from myosin, it was said that he just took on the risk, and if you take on the risk, well, you've got to accept that it might not play out for you.
Correct.
Is the risk then that people, when I say people, I mean parties, are they going to be less willing to take on that risk following myosin? And are we going to see more final hearings because people are going to say, well, I don't feel if I'm going to be saddled with the consequences of the risk and there's no way out afterwards, then I'm going to be less comfortable nailing my colours to the mast when it comes to outcomes?
Well, I hope not, because I think they would realise, or certainly be advised, that if it goes to trial, there will be a determination one way or another, and it might be a determination they don't like. If an individual is concerned that they are going to be saddled with all the risk, and the other is going to receive all the copper-bottomed assets, as it were, the standard Wells and Wells type scenario, sharing risk and reward, then the answer, as I said, is share the asset in question. Both can take the risk or the reward. That's the answer. If you're concerned about settling because you don't know what will happen to the value of your assets next week, then share the assets. Both will take that risk. But what I don't think is a sensible thing to do is to simply say, we can't deal with this now, and I'm not willing to resolve my matter because I don't know what's going to happen next week. One can say, I'm going to wait and see what will happen, but there's always the concern about what will happen tomorrow, what will happen next week, what will happen next month. It's very rare you get to a point where you say, actually, I'm now content that everything has settled down. No, that's the nature of life, that there are unknowns which occur all the time.
Well, one reason might be because a final hearing might not take place for another 4, 5, or 6 months with the way that listings are working at the moment, particularly if we're going to have even fewer judges. So maybe clients might think, well, it's a reasonable thing for me to wait, 4, 5, 6 months, and maybe I'll settle just before the final hearing when all of this has settled down a bit. Is that not an unreasonable position for people to take?
It's not an unreasonable position to people to take. I'm not sure it's a particularly sensible position for people to take, because all you're doing is increasing your legal costs and not necessarily advancing the case any further.
Yeah. Well, Helen, one of the things that strikes me as an interesting comparison is the role that cryptocurrency plays in financial remedy cases. I mean, I've only done a couple of cases involving cryptocurrency, but it is something I'm interested in. And the case that we had, I can't remember the exact figure, but let's say £800,000. And if we were to draw a graph of the cryptocurrency's value during the proceedings, it was very much as exact as it was going on. And at any given moment in the hearing, it was either worth $1 million or was worth as low as 500,000. It was extraordinary how the fluctuations were going up and down. I think it was a particularly volatile period of time. Do you just think that this is just another thing like cryptocurrency that the court is able to deal with and not to worry about?
Well, I agree with Ben. I think the court has to deal with it, or the parties have to deal with it. And any item, any chattel, any piece of land is going to have a value which may be one particular value on one day, one particular value on another, or indeed hour by hour. And you simply don't know what's going to happen with the economy at any one point. And COVID-19 could have very major impacts on economies, national and international. And cryptocurrency, of course, falls outside of general standard economies. But it's so uncertain. The fluctuations can be so great, and depends on what cryptocurrency you're dealing with as well, that I do think you simply have to take the value on the day that you've got it there, and then say, right, are you going to have to share it? If you're looking at financial arrangements, you're going to say you're going to share it, or is one party going to take the risk that it's going to be worth a heck of a lot in 3 months' time, or zero? It's the same Meyerson argument again, and as Ben said, the Wells and Wells point. But I think it's a good analogy. It's analogous to what's happening with shares at the moment. Shares, as we know, are really sensitive to what is going on at the moment with the state of the economy and what's happening with general shutdowns of various businesses or suspensions of businesses running.
Sticking with you, Helen, one barrier, of course, to settlement could be valuing companies or valuing other kinds of asset. How would you feel about making an application for an expert instruction of a company right now in the present climate? Is that a sensible valuation when that report is going to be caveated so much by economic climate? We'll have to wait and see, come back to me maybe when things have settled down. Are experts now going to be caveating all of their reports? Do you remember how every time you used to get a property valuation during Brexit, every valuation report would have a whole paragraph, the Brexit paragraph, which would basically say, this is all completely subject to Brexit, and I, reserve the right to completely change my mind. What do you think about experts providing valuations in financial remedy cases?
I think certainly for private limited companies, private companies, you're still going to be engaging experts, because you still need somebody to say, actually, what's another person who might be interested in purchasing these shares or this interest likely to pay for the interest that's available within the proceedings. I think you still need to have an idea of that. And all the parties need to have a figure, because they need to know what they're looking at in relation to division. They need to know what they're looking at if they're going to share these shares, or they're going to transfer an interest from one person to the other, what their likely tax obligations are going to be. So all of that does have to be valued, and you have to take that into account. Whether or not what you're going to be saying is, we're going to adjourn the capital division until 6 months and see where we are then is something that I think does have to be taken into account. So you might get as far as what a court thinks ought to happen and then adjourn the capital claim, or say one party has. I suppose the only situation really that we've had recently with adjournment of capital claims is the Quan and Bray approach, where one party has behaved, as far as the court is concerned, not very well. But that is an option that's open to courts and open to parties to say, OK, well, if I can stomach it, then we'll adjourn that claim.
Yeah. I mean, Ben, it's not just capital that is going to be affected, it's also going to be income. And starting with the interim position, is the court going to be flooded now with lots of applications for variations to orders that have already been obtained, in your view?
Yeah, I think it's almost inevitable. Every time there's a difficulty with the economy, in my experience, there tends to be a flood of applications to vary downwards, usually downwards maintenance, that is, on the basis that we had the issue previously with the recession, where bankers' bonuses dried up and suddenly critical payments orders couldn't be afforded anymore. There was a flurry of applications with downward variation. And if we are, as we spoke about earlier, in a position where people are going to be, particularly the self-employed, where people are going to be unable to work for all sorts of reasons related to COVID-19, then that inevitably is going to impact on their ability to afford periodical payments and ultimately the fairness of the original order. And that is a fundamental of a periodical payments order. It's inherently variable. And if it's no longer fair, then either party is entitled to apply to the court to have it varied. And I suspect we are going to see a lot of those applications, yeah. Now, how they're determined and how quickly they're determined, that's another matter. But yes, the short answer to your question is undoubtedly there's going to be a significant increase in forms they issue to seek variation. Yeah.
Because I think it affects so many different levels of employment, doesn't it? Because you're effectively saying that any job that has any kind of public facing element to it or any kind of travel to it is going to be severely affected for the foreseeable future. That's effectively what you're saying. And, that affects at one level, people working in, coffee shops or bars or restaurants who simply aren't able to go to work, or if they are expected to go, if they do go to work, then they're potentially running a risk. Come back to that in a minute. But at the other end, you've got people in very high level positions. I mean, I'm a big football fan. Footballers are in an interesting position. I mean, look, nobody's going to suggest that they're impecunious, but their contracts are actually very incentivized. So their contracts are based on, playing 90 minutes, scoring goals, assisting goals, touches, passes, meters covered during. There are loads of metrics that then lead to financial incentives within the contracts. They're not meeting any of those because they're not playing. And football has been postponed for the foreseeable, which I can tell you is a great source of anxiety and concern for me. I suddenly find myself at weekends with a lot more free time, which is a worry. But that I think it's interesting to see how many contracts are just going to be not fulfilled as a result of this. And then as you look at chains where one contract affects another, how it goes down the line. I mean, Ben, just sticking with you for a second, what would you say in a variation case, not to somebody who has lost their job or can't work, but what would you say to somebody who says, look, I'm not prepared to take the risk. I think it's too risky. It's not safe. I'm going to just stay away from doing my job because I don't want to expose myself to the risk of getting COVID-19. And so I'm going to, in that way, artificially reduce my income, albeit perhaps maybe for understandable reasons.
Well, it's always up to the court to conclude that someone's unreasonably reduced their income. And if the court concludes that someone has unreasonably reduced their income, that can absolutely impact on the order the court makes in respect of any application for variation. Having said that, I think it's going to be very difficult for the court to investigate the reasonableness or otherwise. It would all be, of course, be absolutely case dependent. But if, for example, a farmer in the middle of the Yorkshire Dales decides not to tend his sheep anymore because he's concerned about COVID-19, I think the court would take a view. On the other hand,
he might have asthma then. That's not a very fair thing to say. He could He could be overweight and 80 years old, for all you know.
He may be an 88-year-old asthmatic farmer. On the other hand, he could be a chap or a man or a woman in their mid-30s who has no underlying health conditions but decides to stop working. Now, that's a different scenario. But what about as you said, the barista in the coffee shop who has taken the view that they don't want to serve the public anymore because they work in a cafe next to the tube station, which is flooded with commuters every day, is absolutely packed, and they are constantly exposed to people who may have or are at risk of having COVID-19. Is it reasonable for them to stop working in that scenario? It's very difficult.
I don't know, is it?
Well, I think the court would have to analyse it on a case-by-case basis. I think it'd be very tough indeed. I think it would be a very strict judge that said it was unreasonable for you to do that in that scenario. But on the other hand, if it left them with zero income altogether, maybe the court would take a view it was unreasonable. I think it's difficult. I think it would have to be investigated. The answer is it's impossible to start generalising.
And Helen, as I speculate about the unintended consequences of COVID-19 on financial remedy cases, we were reaching, I think, a point where maintenance orders, spousal maintenance orders, I should say, were becoming shorter. The judges were being harder on parties and more demanding about them getting back into work and saying that, I'm going to give you a period of time, and then after that, you're on your own, got to sort it out. And joint lives orders were becoming incredibly rare. And I'm sure all of us remember at the start of our careers, and I'm not going to name any names, but I can remember negotiating FDRs at the Central Family Court and being told, well, if you don't give me a joint lives order, I know I'm going to get it at a final hearing. So that's something we'll go all the way on. And you just did, because it was just the thing. Joint lives orders were the thing at the Central Family Court. No longer. I think it's the exact opposite. But as we speculate about how the effect is, do you think that one consequence could be now judges are going to be less inclined to bring a guillotine about when it comes to people's ability to reach financial independence because of the economic climate, because of the uncertainty that everything's causing? And do you think that we could start seeing judges lean perhaps back towards joint lives orders and just say, there's no fixed time where I can predict when this person will be able to adjust without unreasonable hardship, and so I'm just going to leave it open-ended and come back to us all when this is all cleared up?
I don't think it's necessarily going to lead back to joint lives orders being par for the course. I do think that judges or parties will need to be more open to having ongoing maintenance in the meantime. And I was interested to hear Ben when he was talking about the applications for variation and how you're likely to see a flurry of applications for a downwards variation. But on the other hand, you've got the receiving party, and we only have maintenance orders now that are designed to meet needs. It's not about sharing in any form, really, and it's really quite restrictive. So you have to say, these are my needs that I cannot meet independently of you, spouse. So you're going to have to make that up, and the courts will do that assessment and will come up with a figure which is, for that particular family or that particular person, a very limited figure. It's not going to be generous. It's not going to be something that they can start stockpiling. Stockpiling orders are rare, really rare, to the point that I've not seen one, I have to say. But those sorts of things that we are what we're going to be looking at now, is saying, well, what about the receiving party on a variation application? How are they now going to pay their mortgage? How are they going to pay their childcare? Are they then expected to go to the government cap in hand and say, now you're going to have to pay me more universal credit or something of that nature in order to make up the shortfall that my spouse would have been providing to me in the meantime? So I think there's going to be more periodical payments orders. The terms will be more generous than they have been to date, but not to the point that they're open-ended. And I do anticipate potentially variations both ways. It depends on who gets in first, really, for the application, to try and prevent the other party from applying for a downwards variation. And I don't think we're going to see as many Section 28 1A bars as we are seeing now or have been seeing to date. So to prevent people from applying for extensions.
Well, look, stockpiling is a super interesting topic and probably something we could spend a whole episode talking about in of itself, because I query the legal basis for it after Wagga and Wagga. But let's not get sidetracked with that. Ben, what do you think about the impact on the term of maintenance orders in the light of coronavirus and COVID-19?
We go back to first principles again, don't we? In terms of period, the court has to conclude that the payee can adjust without undue hardship, as you said, to the termination of maintenance payments. That's still the law. In a scenario where there is significant economic uncertainty, which there now is, and there is a distinct lack of stability, I think it becomes increasingly difficult for the court to conclude that in X years, somebody can adjust without undue hardship to the termination of maintenance. Again, it's all very fact specific, but if somebody doesn't have a job currently and the court is typically saying, well, I think this spouse can obtain a job, I think they can obtain it with historically they'd say, or traditionally they'd say, well, I conclude on the balance of probabilities this spouse will enter the workforce within 18 months. They'll be working part-time at this level. On the balance of probabilities after 36 months, they'll be at this level. And courts have generally been able to make relatively confident predictions about what they think a spouse would be able to do. I think that's going to be much more difficult now in an economy where there may not be the same opportunities available, subject to what happens over the next couple of months. So the very short answer to your question is, I think terms are probably going to be longer, generally, I would suspect, simply because I think the court is going to find it harder to say that in the current economy, they can conclude that that spouse can adjust without undue hardship to the termination of maintenance payments.
So yet another shift in the philosophy of spousal maintenance in a short space of time. But can we talk about international cases? Because you know, I really like international cases, and I think they are super interesting. Not just because I'm a geek, but probably because they objectively are. Can we talk about forum necessitatis? Because could we not be confronted with a situation where international clients are unable to issue proceedings in Ireland, Spain, France, Germany, insert other European country, and obviously we still are subject to the maintenance regulations when it comes to jurisdiction. What do you think about the ability to persuade an English judge that one should be able to issue in England because those courts are unavailable, and not look like you're simply trying to take advantage of a desperate situation?
In a case which isn't covered by the Brussels regulation, where an individual simply cannot issue proceedings in a foreign jurisdiction because they can't get to that foreign jurisdiction, then I think that clearly.
But they have a connection to England, so they have the connection.
Absolutely.
But unable to proceed in the other one.
Unable to proceed in the other one, that absolutely there's an argument for issuing it here. Of course there is. Yeah.
And do you think that there is scope for Europe to revisit the Lee Pendens rule? Because obviously at the moment you could be in a situation where somebody rushed off and issued in a court which now isn't sitting for the next 2, 3, 4 months. And maybe a sensible solution to that would be for forum conveniens to come back into it. And let's just say, for example, that England becomes very progressive with remote hearings. Managed to refer back to it again.
I can see where this is going.
Offers a access to justice that the alternative European country isn't able to offer. Do you think that forum conveniens would be more appropriate in this climate of emergency than the arbitrariness of Lee Pendens?
It's a nice idea. It's not going to happen, is it? I mean, realistically, if we're talking about delaying court hearings for 3, 4, 5, 6 months, the answer is going to be that the court hearings are going to be delayed for 3, 4, 5, 6 months. not that Europe is going to introduce brand new legislation that entirely subverts the intentions of Brussels 2 bis.
But let me play devil's advocate with you, Ben. What about if there is an urgent need for interim maintenance, or for freezing injunctions, or for protective orders? And I appreciate emergencies are probably covered by these countries, but we're just hypothesizing here. Let's say that it's just not possible to get those kind of orders in that country. Surely then you can't say to somebody, well, just wait 4 months and come back with no money, all the money's been blown down the casino, and you'll just have to get on with it. Surely that would provide a good reason to move into a foreign conveniens based assessment.
I can see the logic behind that, but that's not going to happen. The answer is going to be, if you are litigating in a European, if a European jurisdiction has seized jurisdiction of the case, if it's first in time, and if you aren't able to obtain relief in that jurisdiction because of difficulties with the courts, I'm afraid, sadly, I think the answer is tough in that scenario. Unfair.
You're saying I shouldn't write the letter to the European Court of Justice proposing. Maybe I'll just do a tweet about it and tag them in it.
Well, I was going to say
they can do with it what they want.
You should write the letter, but I suspect you will anyway.
Yeah, they can ignore it just like everybody else. It's fine.
Yeah.
Helen, anything to add on international aspects, or would you like to talk about child maintenance?
Let's move on to child maintenance.
Yeah, because I think child maintenance is really problematic for me, because I was having a discussion with somebody a month ago about the efficacy of the child maintenance service. I mean, I've been involved when I was at the bar with child maintenance tribunals, and I got mixed feelings about them. I think that there are some fantastic people actually who sit on those tribunals who do, in large part, a good job. But I can't help but feel that child maintenance wouldn't just be better served by being dealt with by a judge and just get rid of the whole child maintenance service scheme. But that's probably the subject of another conversation between us three. What I'm interested in with child maintenance is all of the children who are going to suffer because coronavirus and COVID-19 gives an opportunity for them to go unmaintained. And if the CMS was unable to enforce, I think, is it a third of cases, or have I got that figure wrong? I think it was a third of cases, but we can fact check that later on, but hit us up on Twitter if I got that completely wrong. But I think it's certainly a significant amount. If they can't do it when things are working reasonably normally, what are they going to do during a national emergency COVID-19 coronavirus outbreak?
It's always going to be the children that are going to miss out, because of course they have no power to enforce these things themselves. People might think about applying for lump sum orders under Schedule 1 of the Children Act if they can substantiate that, say, well, these are the things that my child needs, and go and make those applications, or threaten an application if provision isn't made for particular chattels or things of that nature. But for an income stream, again, it's another thing that is going to be impacted by the ability of people to work and to keep an income coming in. So I don't think it's just about whether or not you're self-employed. I think it's going to affect all areas of work, of paid employment. And companies are going to be forced, I think, to take steps to rationalise their workforces, and that is going to come with redundancies and with or people being asked to work fewer hours to maintain their jobs. And in those circumstances, incomes are going to drop, and children, parents and children are going to lose provision for them to make sure that their needs are met, that bills are paid, that shoes are bought, that food is put on the table. It's going to be tough if this hiatus goes on for any substantial period of time.
Yeah, well, you'd like to think that people aren't going to try and take advantage of it, but sadly, I think there might be some people who will try. Should we move on and talk about children and the effect that it's going to have on children proceedings? Unless, is there anything that I've missed with regards to financial remedies? Helen, when we think about children proceedings, there are numerous ways in which COVID-19 and coronavirus is going to affect the way that children proceedings operate going forward. But can we focus on private law proceedings to start with? I have a question for you. Is it legitimate to be in breach of a child arrangements order using the justification of COVID-19 and coronavirus? So could I say, I'm not going to make the child available for time with you non-resident parents because either we're self-isolating or I'm not sure where you've been, I don't know whether you've got it, I'm not going to let you see the child until you produce a negative test every time you see the child. I have elderly relatives, the child has asthma, I have asthma, all of these reasons. Is it appropriate to use that as a reason not to comply with the child arrangements order?
I think we're going to see those arguments being made. I think it's going to ultimately depend on the quality of evidence that's going to be given. And I do think there will be contested hearings in relation to it, because I have no doubt that people will make these or say these are the reasons why I'm not making the child available at a particular point in time. I do think it's going to happen, and it's going to be contested because the other party or the child is going to be at the very least disgruntled, otherwise harmed by it. It's an easy excuse for a parent that does want to interfere with the relationship with the other parent and the child to use, and it's going to be difficult to counter it at this stage. Again, there's going to be no doubt a slew of applications that come before the court. The court is extremely stretched, and we are yet to see how that will play out. I do hope that children will be made available appropriately, but also they do have to be protected, and families do have to be protected from the spread of this disease. One wants people to be sensible about it, but what is common sense to one person is not common sense to another. What is controlling behaviour by one person is a difference of opinion to another, and I think we see a lot of that in the family courts anyway, and I think we'll be seeing a lot of argument about this in future.
And Ben, my mind turns to CAFCASS officers, because you know, the job of a CAFCASS officer is ultimately to meet lots of different people every single day, to go to their homes, to be at court, meeting people, meeting children. Can CAFCASS officers reasonably expected to carry on doing their job in the current climate? And you know, we were talking about having remote hearings and what you would lose through things like cross-examination and body language reading when it comes to seeing somebody remotely. If CAFCASS officers are reduced to seeing people via Skype or via video link, they're going to lose a great deal, aren't they, in terms of the insights that they would have with regards to children?
It's impossible. It's impossible. You can't meet with a child via video link. It's one thing suggesting you conduct a court hearing via video link. It's another thing suggesting that you actually meet with a child and understand their wishes and feelings and try and report on what's in their best interest, and have only done it by way of a remote video link. It's impossible. It's absolutely impossible. I don't know what the answer is. I actually would be fascinated to know what guidance has been given to CAFCASS officers and social workers generally, actually, about.
It's a really good point.
Yeah, I just don't know. I don't know. I'd love to know the answer.
Because I think they are, social workers and CAFCASS officers are even more at risk than judges, practitioners, court staff are, because they're literally going to people's homes. You know, they are, and lots of people's homes. I mean, I don't know what the average number of houses that ISW or a social worker or a CAFCASS officer goes to each week, but it's going to be at least one a day, I would have thought, and maybe more. And so their exposure is going to be huge, and they play such an integral role in the child proceedings. It's hard to envisage what the court's going to do without them, isn't it, Ben?
I have to say, this is the one topic on which I simply don't know what the answer is here. It's again, I think we'll have to see what pans out. But if the worst comes to the worst, the entire system is going to collapse around its ears. The role of the CAFCASS office is absolutely vital. And if CAFCASS officers are not meeting families and children, I just simply don't know what the courts are going to do at that point.
No. And Helen, one of the other things that troubles me greatly is domestic abuse situations, because we could be facing a situation where, I'll give you an example. In one of my cases recently, a mother has recently had surgery and she fled the former matrimonial home because of domestic abuse, and she went to go stay in a hotel. But of course, staying in a hotel is a disastrous thing to do if you've just had surgery and your immune system isn't what it is, and people are coming in from the airport from anywhere in the world. You're putting yourself in a vulnerable position. Are people with freedom of movement potentially being restricted by people being encouraged to isolate and remain at home, by having public spaces closed down, resources closed down? Are vulnerable people going to be placed in situations that they are going to be exposed to even more harm than they otherwise would have been?
Yes, is the short answer. There's no check, no balance. If people aren't going out, people aren't seeing other people, no one's making sure that people within their homes are all right. Of course, it's not just physical violence that's necessarily a problem. Emotional abuse and financial abuse, all of that has a huge impact. Coercive control has a huge impact within the home. People enduring this behind closed doors and with no immediate recourse or safety. If you haven't got social workers who are able to go into the home to check the safety of the children, that's a real problem as well. They're in amongst all of the YouTube videos of the Italians singing and playing music on their balconies to their flash mobs to engender solidarity. There are also snippets of people on balconies enduring domestic abuse at the same time that have been taken out and publicised now. It's a real problem that's happening. And is happening behind closed doors, but it's going to happen more frequently, and children are going to be impacted by that. Also, what happens if you can escape? If you're going to a refuge is going to say, sorry, you've got to be tested. We can't risk the other people in the refuge in case you've got coronavirus or symptoms within that refuge. That's going to be a real problem. If you're bringing children, they haven't been tested. Are they the super spreaders? Are they going to bring problems to refugees? So all of these things are serious concerns now that the courts are not going to be able to deal with, and that authorities are not going to be able to deal with. I do think there's a greatly heightened risk to already vulnerable people in those situations.
So, Ben, when we think about temporary leave to remove, I can think of lots of ways in which COVID-19 and coronavirus is going to create issues for the courts for people looking to go to other countries on a temporary basis. Let me put a specific example of that to you. Is it reasonable for a parent to take a child to visit a relative in another country presently who is suffering from COVID-19 and coronavirus, and let's say that the reason is that they're worried that this might be the last chance they ever have to see that person, and this might be their opportunity to say goodbye, and they're a very important family member. Is that a reasonable thing for somebody to ask the court to allow them permission to go and do?
Well, I think it's an extremely difficult question, isn't it? But my gut feeling is that it's probably not reasonable to take a child and expose them to somebody who's got COVID-19. My gut feeling is to say, no, that's not a reasonable thing to do. But I think it would all depend on what the circumstances were. Would this child come into contact with this individual or not? What provisions are in place? Which country are we talking about? What's the situation in that country? I think it's impossible to generalize and give definitive views, but you're absolutely right. These things create enormously difficult issues. I suspect there are some scenarios where the answers become actually very simple. I imagine if you sought temporary leave to remove a child to North Italy, you'd find the matter could be dealt with relatively swiftly, I'd imagine, at this moment in time. If you sought temporary leave to move the child to Iceland, I don't know what the position is in Iceland at the moment, or in Madagascar or Costa Rica. I simply don't know. But you're absolutely right. The question of temporary leave to remove, and probably permanent leave to remove, now inevitably is going to require an investigation into what the situation is with COVID-19 in that jurisdiction.
We'll come on to permanent in a minute. Let's not jump the gun. Let's stick with temporary.
Yep.
And sticking with you as well, Ben. Yep. What about expert evidence? Because of course, I had a potential new inquiry that it feels like 100 years ago. It was probably only a couple of weeks ago. He was asking us about the relevance of COVID-19 and coronavirus. I looked into it at that time, and I was interested in looking at what expert evidence would be available to us to put before the court, because of course at this stage, 2 or 3 weeks ago, our knowledge was far less than it is now. And so I was potentially thinking about a situation, well, would the judge even know much about this? But of course, that was a foolish thing to think, because obviously now everybody's an expert apparently in COVID-19 and coronavirus, and maybe there's no need for any expert evidence whatsoever. But if you did decide that expert evidence is required, I mean, it's just not feasible, is it? Because one, nobody really knows anything about it. Ultimately, those who do are doing it on a limited data sample. And two, the people who do know a lot about it are kind of busy at the moment and trying to work on things like vaccines. So do you think that expert evidence is just something we're going to have to do without when it comes to making these decisions for the time being on that particular, aspect of things?
Yeah, well, 2 points spring to mind. First of all, what is this expert evidence going to say? All this expert evidence is going to be able to do is give some opinion about a range of risk on which presumably there is no consensus anyway, number one. Mm-hmm. And number two, the point you already raised, that it felt like a million years ago, but was only 2 weeks. The situation is changing so rapidly that what is the worth of an expert report produced on a Monday when on Friday the world will feel very different again?
So true.
Yeah, I totally agree with you. I don't think there is much use in an expert report. I think actually what you'll end up doing is you'll having competing statements from the parents, and the judge is going to have to make a determination on that basis. Yeah. And I feel sorry for any judge that has to make a decision on that basis.
No, I agree with you. Well, Helen, let's talk about permanent leave to remove. I mean, I've got a problem. I do a reasonable amount of leave to remove cases. I have final hearings coming up about relocations to lots of different parts of the world, from England, and actually from those parts of the world to England, as a reverse leave to remove, which is a very interesting subject. Again, probably for another day. What am I to do? Because, the world's in chaos. How can any judge decide? And I'm going to caveat this, by the way, because if I'm opposing any applications for adjournment in the next few months, I want to be clear that I'm fact specific when it comes to adjournment applications. Please don't think that this is an endorsement of any adjournment applications that the other side may make. But how is a judge to deal with the prospect of the world being in chaos and international travel just not feasible at the moment?
Well, the thing is, when you're making an application for permanent leave to remove, invariably you're saying, I want to move to that place because I have support, or because I have a job, or a combination of the two, or life is going to be better for me and the child in that other place. And here's the evidence that I have very carefully collated and put before the court in my initial application. And that is what the court is going to be considering. So what the court presumably will do at the hearing is then say, well, are those circumstances still in place? Is there still work available? Is the family still there? Is it a safe place, assuming that it has a proper, well-structured healthcare system? Is that available? Do all the other circumstances remain? And in those circumstances, I think permanent leave applications are much less fraught than temporary leave applications. Okay, so for the temporary leave application point and expert evidence in relation to that, invariably what you're asking the expert to do is tell you about safeguards for return of a child. That's what you're looking for in temporary leave applications. And what the legal system has in that particular country in place to ensure that the child will be returned if the parent doesn't return the child. And so in those circumstances, it really depends on how the court system or the legal system or whatever authorities are in place are functioning that would assist with the expert evidence there, if that's functioning at the time. And as Ben said, everything's changing. So the temporary applications, I think, are much more fraught now than the permanent applications.
But let me play devil's advocate with you there, Helen, because actually a big part of leave to remove applications is talking about the new life that you've created for yourself in this other country, and all of the things you put in place, from your job to schooling to look at this beautiful park that we'd be able to go to, which we wouldn't be able to go to if we lived in our flat in London. All of that's out the window now, isn't it? All these carefully constructed new lives that have been carefully put together in witness statements, they all need to be rewritten now, don't they? The world is a different place.
It depends. It depends. If the work is still available, if those facilities are still there and they're likely to be there in 6 months' time, a year's time, is that what you're saying then is a reason for the permanent removal? Or otherwise, if it's for familial support, because you've got all your family there and you haven't got any support now and you're separated from your spouse or your partner in the place in which you were living, in those circumstances, I think the question of permanent removal still remains more certain, provided you've got your application properly in order, than the question of temporary removal.
Now, Helen, we discussed when we were talking about financial remedy cases, the case of Meyerson, which is a story of risk and taking on too much risk and bearing the consequences of that risk. I'm not aware, and probably just because of my own ignorance, so please help me out if I am missing something, but I'm not aware of a comparable children case where the court made a decision and then the world changed that arguably could call that decision into question. If you had a leave to remove decided in the last, let's say, 3 to 6 months, and the move hasn't taken place yet, obviously, would you be minded to think of bringing an appeal on the basis that if the judge had been made aware that the world was going to be plunged into the chaos that it is in now, they may have been more likely to err on the side of the status quo until said crisis had come to an end?
I don't think you'd even need to appeal, because you're not saying, well, the decision was wrong or the decision was wrong at the time. You're asking either for a set aside or for a new order. So you just simply make another application for a different order to be made, because Children Act proceedings, of course, never really come to an end. They fluctuate, and you can make more applications or other applications until the child is 16 in effect, and beyond in certain circumstances. Would this be an exceptional case if the child were verging on being 16 years old, for the court then to exercise a Section 8 jurisdiction, apply the welfare checklist again, and say, actually, is it in the child's best interest to make that move now? And I think that's where you'd be looking. I don't think you'd be saying, I've got to appeal, I've got to have permission now to appeal this decision that was made.
And Ben, you looked very disapprovingly at me during that question. But I can tell you disagree with the way it was put. I know I called it appeal rather than set aside. So let's get that one thing clear on the table.
Not even a set aside. I mean, a set aside suggests fraud or mistake, and an appeal is the court has made an error at the time. I think Helen's absolutely right. The answer would be you'd make an application for prohibited steps order, wouldn't you? Prohibited steps orders to prevent the removal of the child.
Yes.
Okay.
And it would have to be, that's effectively the remedy, isn't it?
Okay. Well, fine. The final thing that I have, thank you very much for just clarifying that, clearing it up. Let's, everybody's had a leave to remove decision, quickly get into court with your prohibited steps orders as soon as you possibly can. In terms of the final thing I wanted to discuss with you is wishes and feelings of children in the context of something like this. You know, we've already established that there probably isn't anybody to take the wishes and feelings of the children available in terms of professionals. So we caveat this question with that problem. But Helen, what do you think of children being able to understand what's happening in the world with regards to COVID-19 and coronavirus? And do you think that it's just something that, you know, children will maybe have a limited view of, but probably shouldn't be lending too much weight to it in decisions that judges are making? And obviously subject to their age and subject to their individual characteristics.
I think their voices have to be heard, and their voices will be heard either through their parents or through CAFCASS in one way or another. I think that will happen. I know that they are, certainly I know from experience that younger children are being told very banal things about the COVID-19 virus in school and how to keep themselves and others safe, and that it might not affect them, but it could affect people in their family, so they need to be very careful about washing their hands and so on, that kind of thing. And that's being instilled in school and instilled in homes. As to what they want, so for example, in a situation where one parent is saying you've got to hand the child over to me under the child arrangements order provisions, the other parent is saying no because great uncle Johnny has got COVID-19 and is suffering, so I don't want you I can't trust you not to bring our child into contact with that person, so I'm not going to permit it. If the child is saying I want to see that parent, is the court going to take that into account? Well, the court will take it into account, but we'll have to weigh up on the evidence that is presented whether or not they can actually say that is safe for that child. Is that in that child's best interests? And there's going to need to be assistance to parents to say, this is how you are going to explain it in a child-friendly way to your child if you can't see that other parent. And obviously, you make use of remote FaceTime and things like that, remote methods of communication. But of course, you can't give a hug through Skype, as was famously once said.
Yeah, which is why I've still yet to get a hug from either of you. But I guess in the current climate, probably advisable.
There'll be an elbow bump.
Yeah, exactly. I'm happy to do that. Thank you very much for listening to our podcast on coronavirus and family law. I know it's a very difficult subject, and we've done our best to keep within our areas of expertise and give an insight into the ways in which we think it's going to affect things going forward. But I think, as Ben said earlier, such is the pace with which things are changing. We'll probably need to do another one in a few days' time just to completely change all the opinions that we had in this podcast. But nevertheless, thank you very much both to Helen Brander of Pump Court Chambers and Ben Fearnley of 29 Bedford Row, and also Simon Gore, who provides us with invaluable assistance, even though we can't see him, but nevertheless gratefully received. And maybe we'll do some more of these in the future. And if we do, we hope you'll join us. Thank you very much.
Thank you.